Hi, I'm Sterk, and I'm here with Michael Pollack, and we're here to talk to you about the Supreme Court's recent decision in Knick versus Town of Scott. And Michael, I'll turn it over to you to give us all some background on the case.
Great. Thanks very much, Stu. And thanks everyone for tuning in. So this case implicates a lot of important property rights and property law principles, as well as the balance of power and authority between federal courts and state courts. So it has to do with the Fifth Amendment to the Constitution, specifically the Takings Clause. And so what the Takings Clause does is it permits government to take private property for public use so long as it provides just compensation. So essentially, as long as it pays you for the property that it's taking. And this sort of comes in two forms. The first is what we all, I think, typically think of as eminent domain proceedings or condemnation proceedings. The government wants to buy your property, physically take title to the property, and make it its own. That's one version of that. And when the government does that, the takings clause says it can, so long as it's doing it for a public use and it pays you the value of the property that's being taken. The other is what are called regulatory takings or inverse condemnation proceedings. That's to say that the government is not taking title to your property, they're enacting a regulation that you believe diminishes its value, diminishes the value of that property. And so then you're going to court to say, hey, that's a taking. I would like to be compensated, or I am required to be compensated for the value of the property that this regulation has damaged. Either way, back in 1985, the courts decided a case called Williamson County. And in Williamson County, what the Supreme Court said is that whether we're talking about condemnation or regulatory takings, you have to pursue your claim for compensation through all of the state courts before you can come to federal court and complain that the state has violated your Fifth Amendment right to compensation. Essentially, you have to exhaust your remedies through the state court system. So that was the case decided in 1985, Williamson County. And then 20 years later, in a case called San Remo, the court, interpreting a statute of Congress, concluded that once you've done that, once you've gone through state court, finally litigated your claim there, then you can come to federal court. Well, what happens then is that you might be what's called precluded from relitigating a lot of the findings from that state court decision in federal court. So the result that some litigators and scholars have found intolerable is this preclusion trap, this idea that in Williamson County, the court set up this requirement that you go through state court to litigate your takings claim. And then, and only then, can you go to federal court, at which point you might be precluded from relitigating some or all of that argument. So the question before the court in Knick was what to do about Williamson County. Should it be overruled? Should it be changed? Or should it be retained? And so for that, I'll toss it back over to Stu to talk through what the court decided.
Okay, thanks, Michael. Well, in the Knick case, first of all, the court was badly split. It was a 5-4 decision, and the majority held that the Williamson County rule was henceforth overruled. The majority decided that, in fact, as a matter of as a conceptual matter, we should separate the taking of property from the award of just compensation, and that the federal claim or the constitutional claim ripened as soon as there was a taking of the property, and the potential plaintiff did not have to wait until the state had denied just compensation to pursue a federal claim in federal court. So the notion was taking occurs at one point, and now all that's left is to try to figure out what's the remedy for that taking, and that remedy is something that the plaintiff could seek in federal court as well as state court. The claim was, in constitutional terms, right as soon as the taking itself had occurred. And the court's primary concern here was that the Civil Rights Act of 1871 grants to parties who have been deprived of a constitutional right by state and local officials a federal forum. And the court's notion was that if it didn't overrule Williamson County, that the combination of Williamson County and San Remo would be inconsistent with the Civil Rights Act grant of a federal forum for takings claimants, and that somehow takings claimants would be second-class constitutional right holders, because in other instances, constitutional right holders would be able to go directly to federal court. And again, Chief Justice Roberts' majority opinion in the case was an opinion for a majority of 5. And I'll turn to Michael to talk a little bit about Justice Kagan's dissent.
Great, thanks, Stu. So Justice Kagan's dissent, for which she filed on behalf of herself, Justices Ginsburg, Breyer, and Sotomayor, takes issue with a lot of the components of the Chief Justice's analysis. I should say as well that not only the Chief Justice's opinion, but Justice Kagan's dissent both cited 2 of Stu's articles. It's actually a total of 3 citations across 2 articles for Stu across those 2 opinions. So we're all very proud of him here at Cardozo, and makes his insights on the implications in a moment all the more valuable. So in Justice Kagan's dissent, she said first that the majority is wrong to call the claim ripe as soon as the taking occurs. Rather, the claim is only ripe once the state finally determines whether and how much compensation you're owed. Right? Effectively, what the Supreme Court, with the majority, has done is require the state to compensate you immediately at the time of the taking. Any delay whatsoever will trigger your right to go to federal court and sue the state and get a finding that the state has violated your constitutional rights in merely delaying the compensation that they owe you. And the problem is that for over 100 years, the court has consistently said that compensation is not required immediately. It's required eventually. And so long as the state provides a reliable process by which you can seek compensation, you're fine. The state has done nothing wrong until you have gone through that process and determined, or it has been determined, that you're not owed any compensation out of that process. And that's all that Williamson County was about, Justice Kagan says, which is that given that the state doesn't need to provide you compensation immediately, of course, it's only natural that your claim doesn't ripen until the state has finally decided to not provide you compensation. So that's sort of the main theoretical point that Justice Kagan makes. The other is a practical point, which is that the court's decision will channel a massive number of cases into federal court. And it's not just a lot of cases numerically. These are cases that rely on complicated issues of state law, because state law is what defines property rights. What interests in property people have and when are defined by state law. And so now federal courts in the first instance will have to be using their time and their docket resources to litigate, discover, understand, and resolve these complicated questions of state law for which they don't really have very much expertise or very much sort of need in our federal system to be resolving. The third and final point I'll mention here, just because it speaks to a broader trend in the Supreme Court the past month or so, is a conversation about stare decisis, so the principle that precedent should not be overturned except in sort of unique and fairly extreme circumstances. So this is a case where the court overturned a precedent, Williamson County, and a lot of Justice Kagan's dissent speaks to the idea that even if you think Williamson County is flawed in some way, the notion that precedents ought not be revisited is an important principle, and one that the court, that majority of the court, has on multiple instances in the remaining last few weeks, and perhaps even tomorrow as well, has seen fit to revisit precedents perhaps a bit more often than Justice Kagan thinks is appropriate. So that's more or less what Justice Kagan's dissent is about, and I'll turn it back to Stu to discuss a few of the implications.
Sure, thanks, Michael. Well, you've already mentioned one of them, which is that the federal courts are now going to be called upon to decide a variety of issues of state law with which they may be relatively unfamiliar, because some of them may not even be members of the bar of the states in which they're deciding cases, especially when we're dealing with the appellate level. And there are significant differences among the states on various areas of state law, as Justice Kagan points out in her opinion. But what I'd like to focus on is a couple of other implications that neither the majority nor the dissent really focus on in the opinion, but things that are going to require significant amounts of working out over the course of the next few years or decades as things move. And the first is Williamson County was a case in which the court articulated 2 prongs of court's ripeness test. That is, a claim would not be ripe, a takings claim would not be ripe until two things had happened. First, the state body had to make a final decision, and second, the plaintiff had to exhaust or had to seek and be denied just compensation through whatever mechanisms the state afforded. And what the court does in Knick is to overturn the second of those ripeness requirements. And the court explicitly says, well, we're not making any decisions about the first one. But what the Knick case does, once you eliminate the second ripeness prong, is it's going to put a lot more pressure on the first prong. Right? That is, until now, a plaintiff knew a plaintiff couldn't go to federal court until the plaintiff had sought and been denied compensation in state court. But now that that requirement is eliminated, we have to go back and figure out, well, when did the taking actually occur? When was the taking final? And for instance, in the Williamson County case, the court held that the taking was not final because the landowner who was seeking relief had not applied for all of the variances that the landowner could have applied for. Now, variances, suppose the landowner puts together a proposal that is not in compliance with the existing zoning ordinance, and the proposal is turned down. And the landowner says, well, that's a taking. Well, what the court in Williamson County said is, well, you can't bring a takings claim then until you've tried to get a variance from the zoning board that would allow you to do what you wanted, even if it was not consistent with the existing zoning ordinance. So now that leaves landowners with the question, if I want to go to federal court, well, when can I go? Can I go as soon as I get a permit denial? As soon as the local zoning board decides this is not compliant? Do I have to wait until I seek and am denied a variance? Are there other sorts of relief I have to seek before my claim is final? For instance, it's always open to a landowner to seek an amendment of the zoning ordinance. Would a landowner have to seek and be denied an amendment before the claim is final? These are all issues that the court doesn't touch upon at all in Knick, but that they may become real issues once we eliminate the second requirement of the Williamson County ripeness requirement, and all of the work has to be done by the first of those requirements. So we still don't know when a claim can come to federal court. The second issue that I think the court doesn't talk about at all, and I don't know whether it contemplated or not, is as Michael pointed out at the beginning, takings cases arise in two ways. And the way the claim arose in Knick, the way the claim arose in Williamson County, is what we would call an implicit or a regulatory taking, where the state doesn't set out to take any property, but the landowner says what you've done is essentially the functional equivalent of taking property without just compensation, so we want compensation. Right? And I think that's where this battle was playing out. But a far larger class of cases are those cases in which the government explicitly decides that it wants to acquire somebody's land for some public purpose. And so what it does is it says, we're going to exercise our eminent domain power to condemn your land, and we'd be happy to pay you just compensation. Now, in those cases, the issue that reaches courts in most instances is the government offering to pay enough? Is the value that the government has attached to the property sufficient, given what the landowner contends the property is worth? Now, typically, there are state law procedures for how those claims arise. The valuation procedures are virtually always decided in state court. And the question is whether Knick's separation of the taking question from the just compensation question now invites landowners who want to dispute the valuation into federal court. So, for instance, what would happen if the state of New York, for an example, decided it wanted to take a parcel of land, and it says, okay, our experts value this land at $1 million. And the landowner, and under New York procedures, once the state values the land at $1 million, the landowner, if the landowner has a complaint, can bring a complaint under the eminent domain procedures law that seeks more compensation than what the state has indicated it was awarding. Well, now that what the majority seems to have done is to separate out the taking from the just compensation. Well, there's clearly a taking when the state announces it's going to take the property. And does that mean that the landowner now can go into federal court and say, well, look, you've taken the property. Now I want just compensation. And I want a federal court to decide what that just compensation is rather than going through the state procedures, which may vary significantly from state to state. I don't think that the court hasn't focused on that issue. I don't know whether it's thought about it, but I'm sure there are members of the eminent domain bar who are keenly attuned to the fact that they now have a route into federal court if they thought federal court was in some way more favorable to them than state court might be. And that's an issue that, again, will probably make it back to the court within a period of time to resolve. Michael, anything else that you want to add at this point?
Yeah, I think I'll just make one quick observation, which ties together a lot of what you just said, Stu, which is that the Supreme Court here seems to be approaching the question of the role of the state courts in the takings or eminent domain process as courts that are distinct from the ordinary process by which land use decisions or eminent domain decisions are made. That's to say that the Supreme Court is thinking of sort of two components of a state law system, one in which the decision whether to take property or what regulations to impose are made, and then separately, this other part of state government, which is the state courts, and they're just making judicial determinations about how much you're owed in light of some constitutional right and some remedy that you're afforded. And that's why the court feels comfortable sort of separating the two, understanding that the first sort of set of government actors is one that it's comfortable saying, subject to all of the confusion that Stu appropriately outlined, the court is comfortable saying all of that will still happen in the state, and then once that's over, you can come to federal court with your claim. The only thing that's different is you don't have to wait to go through state court. But what that holding suggests is that there's a distinction between the state court process and the state government process, the administrative process by which your compensation is determined or by which the regulation is enacted. And that's not true, right? As a matter of state law, it is the courts that are part of that ongoing administrative process. That's why you're supposed to go through multiple stages, for example, through your zoning board, through the Board of Adjustment or the Board of Zoning Appeals, and on into state court. And only once that whole process is ended is it fair to say that the state process has come to a close and now you can litigate your constitutional claim. So the court's mistake here, one of the court's mistakes here, is arguably that it fails to see state court judges as members of this ongoing administrative process in this context, rather than as separate judicial decision makers. And incidentally, that's something that I'm working on in an ongoing paper about the role of the state court judges outside of what we might think of as judging, but instead in a whole number of quasi-administrative contexts. This is just one of them, but there are a lot more. So there's real tension here on a theoretical level in terms of what role do the state courts play in this system, and that spills over into the theoretical tension and the practical tension that Stu outlined on the property law side.
Thanks a lot, Michael. So I appreciate your interest in this matter, and we'll just see where Knick takes us over the course of the next decade or so.
Absolutely.